Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Collinson. Mr. Collinson, please state your name for the record.
Your Honor, this is Michael Collinson.
We're diving straight into a heated probation hearing with Judge Simpson presiding over Michael Collinson's case. From the very start, the atmosphere is tense. Michael stands accused of tampering with his court-ordered tether and facing discharge from treatment, 2 violations that could send him right back to jail. But here's the catch. Michael insists he's innocent of tampering and says the real issue is a dental emergency gone wrong. Right away, we can see how this case is about more than rules. It's about survival, housing, and whether the justice system will give him another chance or slam the door shut. What's fascinating here is the framing. Michael isn't just fighting legal accusations. He's fighting to keep the stability he's clawed back from years of addiction and homelessness.
So, Your Honor, I guess there's kind of 2 pieces of why we're here. There is an allegation of Mr. Collinson's tampering with the tether, I suppose, and then his discharge from treatment. And I'd like to address both.
Really?
I hope that the court got, regarding the tamper, I think that, I've had an opportunity to speak with Mr. Collinson for a long time about both of these issues. Looking at the pictures, to me, it looks like wear and tear. Mr. Collinson was brought in with the tether still on his leg. He was in the jail for, I think, 2 days.
The cuts in the strap are wear and tear?
The defense is quick to downplay the tether damage, calling it nothing more than wear and tear. But Judge Simpson, and frankly anyone who's seen how strict these devices are, knows how suspicious this looks. 2 parallel cuts, both deep, both in the same place. That doesn't exactly scream accidental. Still, the attorney leans on logic. If Michael really wanted to escape supervision, why didn't he just take it off completely? That's a strong point. But here's where viewers should weigh in. Do you buy that argument? Would a man desperate to keep his new housing really risk it all by slicing at his tether? Or is this just a convenient story dressed up as bad luck? Comment below, do you think the cuts were intentional or just coincident?
One of the cuts was, I think, already there. There was like a slit in it. As he wore it a few months ago, he noticed it getting worse. So that has been there for months, and there was no allegation that I did not receive a violation report that it was cut. And I think the second one is kind of similar. It seems to be about the same length as the first cut. And from the rubber in between is kind of looking like it's weakening to me. Again, it was not removed from his leg by him. It was removed by the services group that facilitates the tethers. So he got, the cut is deep, but there's no, if he wanted to, he could have gotten it off. I think, like I said, it's been looking like that for a couple months, and there was no prior allegations that he was tampering with it. He's been wearing.
Saying it is just by happenstance that these 2 cuts that are almost an equal distance happened, cutting through the one part of it that you're saying that's just wear and tear.
Yes.
Okay.
Yes. Again, if he wanted to get it off, he could have gotten it off. I don't understand
I had no reason to cut the tether.
if he was trying to evade tracking or anything like that. If he did do those cuts, he could have gotten it off, and he didn't. He came to jail with it on and had it while he was in custody. He's had it since May, and there's been no other allegations of tampering with the tether or evading tracking or anything like that. Again, Mr. Collinson denies tampering with it at all.
Your Honor, I had no reason to tamper with the tether. I ran from the dentist the moment they told me they were going to discharge me.
This is where Michael himself takes the stage, and it's emotional. He doesn't talk about escaping probation. He talks about housing, his newfound stability. He pleads with the judge, saying, "My biggest concern isn't jail, it's losing my housing." That right there is a powerful moment. This man has 74 days of treatment under his belt and over 120 days clean. For someone with his history, that's not small. But the contradiction is stark. He admits running from the dentist straight to a rehab facility, almost like a man scrambling to cover his tracks. It's both sympathetic and suspicious. And here's the question for you. Is desperation proof of sincerity, or does it signal guilt?
The biggest concern I have here, Your Honor, isn't going back to jail. It's losing the housing that I gained in my sobriety here. I have a lot of, through the blessing of the court, I've made a lot of successful gains. I've completed 74 days in treatment. I never had a behavioral problem at Dawn Farm. The new treatment facility, there was just turbulence. This all has to do with the dental appointment. That's why I get concerned when we're talking about tampering, because I thought this was all to do with being discharged from Oakdale on the leave of absence. I have the contract. I called Oakdale for pickup at 3:30. I was supposed to return to.
How about I'll start and you can add. So turning to the issue of discharging, I think what Mr. Collinson was starting to say is he went to Oakdale. He was at Dawn Farm from May to July. He moved to Oakdale because he got housing through HUD, which he would move to that housing at the beginning of August. He has plans for DTE to turn on the utilities on August 6th. So he moved to Oakdale, I think because the program was a week less, he could complete Oakdale and then move into his housing. I haven't been able to contact anyone at Oakdale. I've made a couple contacts and they haven't gotten back to me. But the reason why we think Mr. Collinson was discharged was because he went to this dentist appointment. The dentist appointment was longer than what his out time was supposed to be. And when he called, they said he was discharged because he misrepresented the time that he was going to be done.
Now the case pivots to Oakdale's decision to discharge Michael. His dental appointment ran late, and Oakdale claims he lied about the time. He says it was an honest mix-up about scheduling, fueled by a serious tooth problem that even the ER flagged. This shows us the brutal rigidity of treatment facilities. Sometimes the smallest mistake, a late return, a misunderstood phone call, can cost someone their last shot at rehabilitation. But here's the question, is Oakdale being too strict? Or is this Michael's pattern of bending rules catching up with him? This is the tightrope judges walk every day, balancing compassion with accountability.
They thought he was going to be done at 3. He ended up calling them, I think, around 4 o'clock. That he was done with his dentist appointment. The other piece is that from Mr. Collinson's understanding, is that they didn't understand or believe his representations about the seriousness of his dentistry issue. Long story short, he has a tooth that needs to be surgically removed. It's rotting out of his mouth. When he was at Dawn Farm, they sent him to the ER. The ER can't really do anything because it needs to go through not a normal dentist, but an oral surgeon. Because of the severity of the emergency, they referred him to the U of M clinic. The clinic skipped the normal 4-month wait and got him in for a consult earlier than normal. So that's why he was there. He has referrals from another clinic that he was going to saying that they couldn't do the service because he needed an oral surgeon, because they couldn't find an oral surgeon in his network. That is why he was at the dentist. He did, once he found out that Oakdale was discharging him because of this, he did go to Spera. He tried to get a bed at Spera, and they did not have a bed for him there.
You can look at the GPS coordinates, Your Honor. Spera is a safe place for me. Spera is inside the Dawn Farm community, which I just did all this time programming. I had no problem inside of Dawn Farms. The only reason I went to Oakdale, Your Honor, was to receive this housing. Dawn Farms is a very open treatment center, so I'm able to go out on weekends with my sponsor. My sponsor is the boss and owner of Home Solutions 101. He's given me employment. He's even helped me pay the DTE that's scheduled to turn on August 7th at Danbury.
This moment is crucial. Michael highlights the safety net he's built, a sponsor who gave him a job, utilities lined up for his housing, and a genuine attempt at building a life outside addiction. It's a reminder that behind every defendant is a human story of progress or failure. Judges often say they want to see proof of stability, housing, employment, community ties. Michael lays it out here like a checklist, but will Judge Simpson see this as genuine progress, or as a cleverly crafted narrative to dodge consequences? And here's a question for you. Should courts weigh potential for success more heavily than past mistakes?
I'm not saying that, what I should have done, Your Honor, is I should have called my facility the moment I found out that the appointment was at 2:30 and not 11:30. I didn't do that. And one thing Don Farm taught me was to own my part. And like I keep going back. I don't know why I didn't do that. It would have, I don't, they say I have a thinking disease, and I don't know why I didn't do that. I should have called them. The only thing I can tell you, Your Honor, is I have 120 plus days clean. I'm before you clean. And that means something to me, and I've gained a lot. I'm not asking for like a let go, but I am asking for like an alternative sentencing that doesn't expand on my homelessness. I messed up the probation you originally given me because I was homeless, and just in this short time to be 5 years homeless and to gain this significant opportunity is really huge for me. My biggest fear in this whole thing, in my thinking, is I don't want to lose this homelessness. I begged and cried on the phone for them to come pick me up. They didn't even give me a chance to show them the paperwork. They didn't give me a chance to drop for them. The wear and tear did start. I ran really fast from the school of U of M on Fletcher Street to Sparrow. Like, I mean, I'm talking, I ran really fast. I've been on Tether before. I ran like a gazelle, man. I ran there trying to obtain bedding, because my thought process was if I could get into rehab before the violation of Tether, that I would be able to argue to you that I did the next right thing. Today I'm at your mercy. I just don't want to lose this housing, Your Honor.
So you're indicating that he's denying that he violated it anyway.
I think, I mean, I know Mr. Collins is very sure that he did not, or very strong, I guess, in the assertion that he did not tamper with the tether. And I guess the discharge from Oakdale by his representation is a miscommunication about this dentist appointment and how long it was going to be, how long he was going to be there, the necessity around the dentist appointment.
I didn't tamper with the tether. I did not try to take off the tether. If you look at the coordinates, I'm not lying.
Well, he wants a hearing on all of this then.
At this point, Judge Simpson cuts through the excuses and asks the real question: do you want a hearing? This signals that the judge isn't buying the story wholesale. He's skeptical, and for good reason. Photos exist of a brand new tether strap when it was issued. Now we see two suspicious cuts. To the judge, that math doesn't add up. This is where the case shifts from emotional storytelling to cold, hard evidence. The audience can feel the tension here. A man pleading for leniency against a judge who's seen every excuse in the book.
Is that what he's telling me?
I mean, I'm asking Your Honor he's done, since he was on probation, he did 90 days in Wayne County. I know Your Honor declined to give him credit for that time. He's done time in our jail here in Washington County. He's been clean for, like you said, over 120 days. He's done almost 70 days at Don Farm and Oakdale of treatment. He has housing that he set up. He has employment through a sponsor that he has set up. I'm asking this court to relieve him of his obligations to this court in the remaining balance, given all of the good things that he has done in the last couple of months. I'm sorry.
I let him out to go to treatment.
I did 74 days of treatment. I'll finish treatment. I will. I'm not trying not.
Blair?
Your Honor, I just wanted to make the court aware. I know that Mr. Collison is no longer on probation in this case. However, I am being advised by the Tether agent, so the court is aware that Right after he cut a strap, and the agent noticed him not tracking anymore, he called and was told that he was kicked out of treatment for a policy violation. They also indicate that they have photos of the tether of when it was installed, and it was a brand new strap, if the court would like to see those.
Well, okay, thank you. Well, I don't know if we're gonna have a hearing. I guess I'm gonna need to see him. I've been dealing with tethers, I don't know how long. I've never seen two parallel cuts. Or tears, I guess, as you're trying to say they are, that are in the fashion that they're in.
Judge Simpson lays it out bluntly. In his years on the bench, he's never seen parallel cuts like this on a tether strap. That's damning. Michael's excuse that the tear made the tether looser on his ankle sounds almost absurd in comparison. This is the kind of courtroom exchange that defines credibility. Do you believe Michael's explanation, or do you side with the judge who's drawing from years of first-hand experience? It's a clash of lived reality, a defendant's desperation against a judge's institutional knowledge. This is also where cases often collapse, not on grand revelations, but on small details that don't add up.
And I've dealt with tethers not as long as Your Honor, but I
Wow, that was an age thing. Go ahead.
I do know. I mean, I think the biggest argument here, Judge, is that it didn't come off of his life. I mean, he was tracked the entire time. He didn't. If he wanted to evade tracking, he could have. I mean, people cut them off all the time, and
That's the argument to make, but go ahead.
it wasn't cut off. And he's represented to me that there was an initial, tear in it, months ago, and
Through the metal.
No, not through the metal. There was a tear in the rubber, Your Honor. I noticed it. We went on a trip to Whitmore Lake from Don Farm. Where I was on a paddle boat.
There was a tear in it. Why didn't you go back over to community corrections and say, I need a new strap?
Honestly, the tear helped because it made it looser on my.
Yeah, on the back of your leg at your Achilles heel, right?
Well,
That's
no,
why it's cut the way it is.
no, Your Honor. It clonks on my. I have a bony ankle, and it just clonks. Your Honor, again, I had nothing. Cutting off the tether would have violated me, and that would have made me lose my housing. And my whole point and my whole day, if you look at I got discharged from Oakdale, Your Honor, on that day.
What I have heard is two. One is that these parallel cuts on the back of his tether strap, or on this tether strap, occurred by circumstances beyond your control. The other thing that I've heard is that you were discharged from Oakdale also for something involving the dentistry, and that was also beyond your control regarding the appointment. The only way I'm going to be able to resolve it is if you want a hearing on it. You're not admitting to these violations.
Here, the judge offers Michael a hearing, the only real chance to prove his innocence. But notice the subtext. Judge Simpson openly admits he has great skepticism. That line cuts deep. It means the burden now shifts almost entirely onto Michael. In legal terms, this isn't supposed to happen. The state must prove violations. But, in practice, a skeptical judge can tilt the whole process. For viewers, this is the moment to ask, is the justice system giving him a fair shot, or has the decision already been made in the judge's mind?
And then I'll make a determination.
I don't think Mr. Collinson wants to admit to the violation, so I think we'd ask for a
And we'll set a
hearing.
hearing.
Wait, Your Honor. If setting the hearing is gonna, if I'm gonna lose the housing, I'm gonna lose the housing. Like, what would I be admitting to? Tampering with my tether? Is that what I would admit to, Your Honor? Is that what the violation is saying, that I tampered with my tether?
Correct.
We have two. One that you tampered with your tether. And the other one being that you left treatment.
But I didn't leave treatment.
Sir, I have heard everything that you and your attorney have said.
I didn't leave treatment, so.
If you want to keep talking, keep talking.
I'm just,
Just don't interrupt him.
okay, I'm sorry, Simpson. I'm sorry.
I'll set a hearing. I mean, that's the best I can do. You can bring me everything and you're saying that there are reasons for all of this, and I'll hear those. But I will tell you with reference to, I don't know in reference to Oakdale, but certainly in reference to the Tether, I have great skepticism in what's being told to the court. So,
If I may just explain to Mr. Johnson, one thing, Your Honor.
anyway, you just set those other things. Oh, no, we flipped them.
Plead guilty. I mean, plead guilty and see what he does. Maybe he'll let me back to treatment.
Sure.
Yeah.
And I've explained to Mr. Collinson that he's entitled to a hearing on the violation. I also advised him that we can call witnesses. He can tell his side of the story to the court. And I think he wants to admit to the violations.
Well, if he's telling me all of this stuff that I just sat here for the past 15, 20 minutes listening to,
Have a hearing.
what
Yeah, let's do the hearing. You're right. You're right. You're right. You're right. You're right. You're right, Your Honor. Your Honor, is there any way that I can be on house arrest to this new address during the hearing to sign the lease
house
agreement?
arrest will require a tether. We've had our problems with tethers, haven't we? I'll set a hearing in this matter, August 13th, 2025, 3 p.m. This bond will continue as denied until we get to the bond moment. Thank you.
No bond.
Court calls case, People versus Mark Reed.
And that's where today's hearing ends. Judge Simpson sets a formal hearing for August 13th, leaving Michael in limbo with his bond denied. Think about the stakes: housing, sobriety, employment, all hanging by a thread. This case captures the razor's edge of probation, where one misstep, whether intentional or not, can unravel months of progress. So what do you think? Was Michael unfairly punished for a medical emergency, or is this a classic case of bending the truth to avoid accountability? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.